Very good afternoon. Hope we will be able to continue until about 5, maybe 5:15, not more than 5:15, because we have to give us 5. Yeah, we aim for 5. Honorable Esparron, Le Toudi, and Le Miel and Arisol. Sorry, maybe you're not in my line of vision, but every now and then, just you turn back benchers today. But whenever you have a point, please just raise your hands and I'll see. Okay, so we will. You wanted to raise a point? Yes, please. Can somebody pass the mic to Honorable Esparron? 238.
The respondent was at the time of marriage suffering from viral disease, in a form, or carry on acquired immunodeficiency AIDS virus. I am not comfortable with this article because now we are talking about zero stigma, zero discrimination as regards HIV/AIDS. And why should a marriage be annulled if a person has contracted HIV/AIDS? We have a changing world, and HIV/AIDS is no longer an issue.
Yes.
With the retroviral,
Okay. Yes.
babies are born out of babies are born from parents suffering from parents with HIV/AIDS, and this is no longer an issue.
Yes, Honorable Brancalawan.
It is an interesting point that is being raised, but I guess many of the reasons for nullity, to grant an order of nullity, is based on information not being divulged at the time of marriage. For example, the whole thing, the issue that we discussed earlier on about the person marries who he thinks is a woman, but then discovers that in fact the partner is a man, but has undergone a sex change. So in the same way, if at the time of marriage the person who is HIV positive does not declare it to the partner, and should something happen to the partner, if say the partner then contracts HIV, then what is being proposed is that the partner who has contracted HIV can actually go to court and say, I want my marriage declared null and void, and all this has to do, I believe, with inheritance. Maybe we will be guided so that the partner who is HIV positive and who has not declared to the spouse then cannot inherit, because the marriage is declared. There is an order of nullity. So it's not a question, I don't think it's a question of stigmatization. I don't think it is that. But it is simply saying everything has to be declared. And if there is something serious that has not been declared, then if you've had a sex change, if you are HIV positive with the possibility of the person contracting the disease and it is fatal, then you have to declare. But it's not.
Yes.
That's the way I see it.
Okay. Thank you, Honorable Ramkalawan. Honorable John Wau.
Okay, thank you. In the same line, in fact, I wanted to point out that it's not only about HIV/AIDS, it's about venereal diseases. So I was just wondering whether it's not unconstitutional as well, because nobody has to declare whether he's got diabetes or whatever illness they have before they get married. Why is it, in this case, certain kind of diseases are compelled to disclose before they get married? Thank you.
You cannot transmit diabetes.
Okay.
No.
Okay.
I know you cannot
Wrong example.
transmit it, but it's a disease. It's still a disease.
Yeah. Okay. Honorable Basil Wao.
Thank you, Mr. Chair. Mr. Chair, actually, the answer is in the answer to the issue raised by Honorable Alcindor is in Article 2382B. And it says that the court shall not grant an order of nullity in the case referred to in paragraph 1E, J, or K. And in 1J it says, Roman 2, unless the court is satisfied that the petitioner was at the time of the marriage ignorant of the facts alleged. So if the petitioner was aware that the person was HIV positive, then he cannot use that to declare the marriage null and void. But if he wasn't aware, he was an innocent party, then obviously he has every right to bring a case of that nature.
Yes. Okay, thank you, Honorable Wao. Honorable George.
Thank you, Mr. Chair. Mr. Chair, I think we owe it to Honorable Afif, who keeps asking us the question, to say that what we're looking at now, which is dissolution of marriage, nullity of marriage, and separation, and in fact matrimonial causes, forms of relief as well, everything up to 257 is from the Matrimonial Causes Act. There are no changes brought. This is, unless the professor corrects me, this is lifted from the Matrimonial Causes Act and brought back into the code without change. It's a repatriation of a part of the Matrimonial Causes Act back into the code. So that said, I would like to suggest, and I shall when we get to the debate in the on the floor of the House, I would like to suggest that we add a new ground of divorce to 230. Now, let me explain. The law with regard to divorce changed in 1993 from a law where you had to prove a ground of divorce, namely adultery, cruelty, or desertion, one of those three, to divorce where there is only one ground proved, which is that the marriage has broken down irretrievably. So we changed that to, basically we imported English law. I was the chair at the time of the Divorce Reform Committee. And we debated long and hard. It was a very high-powered committee made up of the two bishops of the Roman Catholic Church and the Anglican Church at the time, one or two PSs, very, very high-powered, a judge if I'm not mistaken. Anyway, we changed the law. We reported that the law had to be changed, and the law was subsequently changed in 1993 to import the English concept of irretrievable breakdown, so that it would be no fault. There would be no fault. You're not in a divorce. There was a recognition that the marriage has broken down, generally through the fault of both parties. Nobody is 100% blameless. So we brought in this English concept of irretrievable breakdown. But, and in order to prove irretrievable breakdown, we went back to the old law, exactly as England had done. You can prove irretrievable breakdown by proving adultery, or by proving unreasonable behavior, so cruelty became unreasonable behavior, or by proving desertion, but also by introducing a new ground, which was that if the parties have lived apart for 1 year and they consent to the divorce will be granted. So, and that was a recognition that parties, just as they can consent to marry, they can consent to divorce. and it was a big step. Unfortunately, we are still constrained by that. We did not, at the time, take the fifth ground in England, which was that the parties have lived separate and apart for 5 years, and the other, whether or not the other party consents. So in England, it was recognized that if two people have lived apart for 5 years, the marriage is as good as dead, so a divorce can be obtained. That was not accepted here at the time in 1993. Oh, it was before 1993, but the law was passed in 1993 because we felt it was a step too far. That marriages had to be protected rather than killed off, as it were, when they had died. So that fifth ground, the committee felt was not acceptable at the time. I would like to suggest that the time has come today for us to have a look at it, to reconsider it, because situations have moved. There are a huge number of divorces. I'm not saying that this is good or bad, but when two people have ended up in court because their marriage is dead, I think a society needs to allow them to get out of the marriage with the least impediment possible instead of putting barriers in their way. Of course, marriage counseling will remain. Of course, the church has got to play a big part, and it does. And I think we've got to acknowledge that. The social services and the probation officers, ourselves lawyers, we occasionally sit with people and try to talk them out of it. But when their mind is made up, it's pointless trying to keep them together. So I would like to suggest that we consider adopting this fifth ground, which is that once the parties have lived apart for a period of time, we don't have to say 5 years, England says 5 years, it's a reasonable time in my view because it shows that marriage is dead, that we can have a divorce. Okay, that I would like to suggest.
I don't know, maybe you can shed light on this situation. What, for a divorce, a party has to make an application and the other party has to be served. In the absence of the other party where you've got no address to serve that party, I've got a situation where, okay, I'll just paint a picture and bring some figures in there. Say you've got a foreigner married to a Seychellois, have a child or not, whatever. Then the foreigner leaves and disappears for 15 years, 20 years. The other partner, the local partner, ends up in a relationship, a ménage, and now finally they want to get married. But the married partner cannot be found. Is there a provision where that person can go and annul the marriage so that she can actually continue her life?
Well, like everything else, even in an ordinary case, sometimes the defendant is nowhere to be found or is avoiding service. And there are provisions in the law which allow service to be made on another place or in a substituted manner, usually by a publication in a newspaper in the place where that person last was. So or
dispense service.
Or you can dispense with service completely in a case where it's necessary. Now, while we're on this subject, the exact opposite of this is something that I think we should know here, and that is, especially in light of the fact that there are now, for every 300 or so marriages of Seychellois every year, there are over 2,000 marriages celebrated in Seychelles of foreigners. And in many cases, those people who get married here go away, and then their marriage breaks down, and they think that they should get divorced in Seychelles because they got married in Seychelles. That is not the case. You must get divorced, or you can only get divorced in Seychelles under Article 229 in certain circumstances. If you are resident here, or if you are domiciled, here is that lovely word again that we saw this morning, in Seychelles, okay? Otherwise, you can't. And there's a very good reason for that, because while you can get married here, the court divorcing you will have to consider, or may have to consider, children and property. And if those children and the property are in England or in Saudi Arabia or in the United States, how can the judge here make orders in respect of them? That's why divorce is territorial. So the judge here will only look at people who are here, where the judge can know and can enforce an order. So therefore, these people who get married here, we have to tell them, well, get divorced in the place where you are, because other countries have the same provision. You can get divorced, you can get married in England and divorced here, if you are here. So the opposite also applies.
Thank you. Yes, Honorable Rumkalam.
Mr. Chair, there's a point that Honorable George has raised, which I don't know whether we've given our approval for divorce. Reasonable period of time living apart should be considered. I think.
But you will move that amendment on
Yeah,
the floor.
but maybe if we say yes, then
Yeah.
it will be part of the committee's report.
Yes.
Saying that.
Saying that one of the ways of proving that the marriage has broken down irretrievably, there are 5 ways of proving it. Adultery is one, unreasonable behavior is another one, desertion is a third one, living apart for 1 year if the other side consents is a fourth one. I'm proposing introducing a 5th one, which is that the parties have lived apart for a period of X years. Let's say 5 years, full stop. All you do is you prove that we haven't lived together for 5 years. Whether or not the other party consents, the divorce can be granted.
Yes, Honorable Aglai.
Yes, good afternoon. Under the dissolution of marriage, but before anybody can go before a court, because we believe in the sanctity of marriage, the moral value of marriage. So, can there be a provision under this code that the person, the married couple, can either be subjected compulsory to some form of counseling before we try to those 5 points, like I mentioned another point, Honorable George, that they are subjected to any form of counseling before considering the marriage dissolution.
Thank you. I'll let AG answer.
If the parties agree, or if one party, for example, normally, before the court, when one has filed a petition, but normally it's when the petition has been filed, then one party said, I want to remain, I don't want my marriage to be dissolved, so I'd like to reconcile. So the court would normally urge them to attempt reconciliation. But it takes 2 to tango there. Yes. 231.
Article 231, Honorable
The
Aglai.
court shall not grant the divorce unless it is satisfied that an attempt has been made to reconcile the petitioner and the respondent. So very often in practice what happens is that one party, when the respondent is served, then the respondent would say, I want to reconcile with my spouse. And the court will give 3 months, 6 months, and either engage probation or social services for them to attempt reconciliation. But in this day and age, it's very rare that reconciliation is a success.
Okay. You want to debate on Honorable George's point, proposal? Or no, Sebastian?
Thank you, Mr. Chair. Maybe Honorable George can clarify. What happens in the instance that one of the parties' marriage is convicted and is sent to prison, and suddenly you have the spouse that, after X number of years, calls in for an annulment, but prior to getting convicted, that person had property, because we are talking about property. In your proposal, you had said whether the other party consents or not. So, in that respect, that person cannot do anything because he or she cannot get out of jail, so to use the term. So, what happens then? If you could clarify, please. Thank you.
Yes, under the old law, the Matrimonial Causes Act of 1937, conviction to a term of imprisonment of more than, I forget what the term was a ground for divorce. It was already in there. Those were done away with, and the one-year separation was substituted. So, Honorable Ramkalawan is making me laugh. He says, well, if the guy is convicted, then he's deserted the family home, so you can get him for desertion. Although it will be a constructive desertion. But essentially, that is the idea. I think if the person is convicted, and the other party wants a divorce, they will be able to obtain it under one of these grounds. Although well, I think unreasonable behavior perhaps is what you could use. That the marriage is broken down because the person has done something which breaks the sanctity of the bond.
Yes, Honorable Pillay?
I don't want to labor this point, but what I'm trying to get at is, okay, you've got the perspective of the person making a request for the divorce, but then you've also got the perspective of the person, that the other party, in that respect. And if there's property involved, and let's assume in one circumstance that the person who has had to be forcibly removed from constructively absent, basically, is then found to have been, how can I say this?
At fault?
Not at fault, and innocent, for instance.
Yeah.
And in that, because it happens.
Are you?
So in that respect, what happens when the other party, say on the urgings of the family or friends or whoever, because of the loss of faith and everything else, decides, put pressure and then ask for divorce. That person hasn't consented to it. So is there any rights that is retained by that person? I don't want to labor this problem. I just want to make sure that we're clear there.
I think if the proposal of Honorable George with regards to time limit, we have to be very careful with whether it's 5 years, whether it's 7 years, especially that we're bringing in. But when they married, how to distribute property? Because you don't want a situation where they use some form of colorable device. I go to prison. I'm still married. It's just that I am not able to be physically present at home. But my marriage subsists. So, however, there may be a situation, especially if the spouse who has all the property registered in his or her name is outside, and the poor spouse is in prison, then I tend to, or for that matter, even somebody in an aménage relationship, because of the 7 years, then I terminate that relationship and deny the person of exactly. So we need to ensure that 7 years or 5 years. But this is a reality here, because a lot of people are caught in a sort of wedlock, but it doesn't. And this is why we'll have concurrent relationship. You have somebody who is at fault. He's the one who committed adultery or whatever, or the fault or the act that has resulted in the separation, but he can't go to court because the court will refuse him a divorce. So the other spouse doesn't want. He sit back and relax and wait until the spouse die for him or her to inherit. So in the meantime, that spouse goes into a relationship, a fully fledged and notorious concubinage, and have two families. So you have one that the law doesn't allow him to go to court to dissolve, and he has to maintain a current one. So at the end of the day, if the amendment proposed by Honorable George, then at least he can go to court and say, look, I've lived apart, separated and apart from my spouse for 5 years, please. But the wife or the other spouse would come to court and say, no, mon marié, sacré, and I don't want to consent. And this is the problem that we face.
How does the guy who has been forcibly removed from the home be present there to defend his cause?
No, he will be, because the prison authorities, he is not prevented from being served with summons for him to appear before a court and defend himself, or to retain counsel for that matter.
I know Honorable Wawa wants to speak, but if I could just answer. You see, there's nothing automatic about this. Even when you can prove one of these factors, you still have to go to court. So even if the other party consents, you still have to go to court and prove that you have lived separate and apart for 1 year. It's not just because on the consent that the court will give you. So if you've been convicted and you're for 10 years, and after 3 or 4 years your wife goes to court and asks for a divorce, and you say, well, no, I still love my wife, I don't want a divorce. It's not automatic that the court will grant the wife a divorce. The court will listen and will make a value judgment at the end of the day. And it may well be that the court will not be satisfied that the marriage has broken down and not grant a divorce. So there is always that residue. Judges are there for a particular reason. They are used to that sort of thing. They are used to making value judgments between two things. So I think at the end of the day, the problem will not arise. While I've got the mic, Honorable Aglaé was concerned that we, and quite rightly so, that we should try and protect marriages as much as possible. Honorable, in 2302, there is another provision, and that is that you cannot get a divorce for the first year. So if your marriage breaks down after 3 months, you've got to wait out the year. And the idea is to try and get people to remain together.
Okay, Honorable Maziluao.
Thank you, Mr. Chair. Mr. Chair, I believe the proposal made by Mr. George is a good one, but obviously we have to explore it before as to how we're going to word it. We need probably to look at the English case law as to how the court in England has interpreted that provision, and then from there we will decide how to word our the proposed amendment. On another note, when I look at the proposed Article 229(1), right now, in order for a party to be able to commence an application in respect of a matrimonial cause, one has to be domiciled in Seychelles, as per the proposed amendment. If I'm not mistaken, under the matrimonial cause, it's residence rather than domicile. To bring a petition for divorce right now, the petitioner needs to be resident in Seychelles.
Domicile or resident?
Yes, but now it's restricted to domicile only.
No, 282.
No, 282 is something else. 282 is something else.
The court has jurisdiction. 282
is about under Article 256. 256 is not about divorce; it's about restraining orders.
No, 29282.
Yes. No, but it is under, it says the court has in respect under Article 256, if a party to a marriage is domiciled, you see? And 256 is restricted to restraining orders.
Yeah, I'm sorry.
Yes, you see? So it's restricted only to restraining orders, but whereas to petition for divorce, presently under the Matrimonial Causes Act, you need to reside in Seychelles. But now it's saying that you need to domicile, which is now larger. Domiciling is bigger than or larger than residence. So we need to consider whether we want to keep the word domiciled or
habitually resident.
We need to consider that, taking into account the present wording of the Matrimonial Causes Act. Okay? And secondly, I know probably this will be done.
I think so, yeah. I don't think so.
And secondly, I know probably this will be done by statutory instruments, but because right now, as Honorable George will be aware, under the Matrimonial Causes Act, there are matrimonial causes rules, and we have prescribed forms as to how one petition the court and so forth. I know we will not be able to put this in the code itself, but do we have in mind that we're going to make these rules? Because presently, the only party that will have powers to make rules under this code will be the president. So are we going to give this duty or task to the president to make these rules? We need to consider that.
Put a rider to say that.
Okay?
No, no. Current rules will continue to apply.
Okay?
Yes, that's right. That's right.
Honorable Afi.
I'm slightly concerned from what I've just heard, in the sense that I just asked the question whether there are any changes that have been done as a result of transcribing these clauses from the matrimonial clauses back into this one. The answer was no. But listening to what Honorable Wao was saying, there are changes. And we were assuming we maintain status quo, but there are changes. And every now and again it seems there are changes, but we don't know what they are because we're not that familiar and we're not sitting with the previous version, the current version, looking at it. So I really would like to impress that we are told clearly what the changes are so that we know exactly what we are. Because it's not very clear. And my second question is, when the clauses in the Matrimonial Clauses Act were transcribed into this one, are there any clauses that have been left out completely, not broken?
If I may.
Yes, Inji?
I think the issue about domicile, residence, etc., I think was raised by Honorable George. You see, with regards to divorce results in issues about children. Who will have the custody, who will pay maintenance, who will have access to the children. Then there's property issues. So in many countries, you have to be domiciled in that country for you to apply for divorce. So a Russian and a Cuban who lives in Dubai, but however, who has their main residence in Paris, has to divorce in Paris. This is where the children, the laws affecting their children, their property, etc., will be dealt with, except unless the property is immovable, then it will be where the property is situated, okay? To a large extent, okay, but it's still moot. So and this is the problem that a lot of people who get married in Seychelles encounters, because they get married in Seychelles, they live in Dubai, they can't get a divorce in Dubai, they come to Seychelles to get a divorce, and the Seychelles court says, no, you are not resident in Seychelles. Now we have situations, for example, where you have Seychellois who were married in Seychelles, but who are not domiciled in Seychelles. They live in London, but they come to Seychelles and get married, or let's say they live in Pakistan, they come and get married in Seychelles because it's easier for them to get a divorce in Seychelles because of the mutual consent. But yet, the Seychelles court dissolved their marriage, but then they have to settle children issues, property issues, whatever other issues that result from their marriage, and they have to go to the other courts there. So this is why, to a large extent, I can understand why it's a domicile, which is the issue, rather than the residence. Because you can then say, look, I'm here, I'm resident in Seychelles for a couple of months, and very often it's just because you are Seychelles, you reside in Seychelles, the court accepts that the marriage be dissolved, but then other problems subsist. And this is the reason why foreigners, people who live outside Seychelles or not domiciled in Seychelles, we tend not to entertain their application for divorce.
All right, thank you, AJ. Yes, Honorable George.
Thank you. Before the professor answers, I thought I would just like to touch on this issue of domicile and reassure Honorable Afif again. If there are any changes, they are, I can't say insignificant because we are all legislators here and nothing is insignificant, everything is highly significant. But it is taken up elsewhere. For instance, this issue of domicile, rightly or wrongly, we went with domicile in 229 rather than resident because of the definition of domicile that we saw this morning in 10, which is domicile means the place where you are habitually resident. So if you are habitually resident in Seychelles, then that's fine. Then you can apply for a divorce. So there will be little changes, but there are changes which are designed to just fit the import or the export where it ends up, and which don't change anything at all.
Yes, Honorable Gillet, and then I'll give the last word to Professor Angelo,
Yes,
and
but
we'll round up with you.
But then because we've seen the word domicile come up in the overseas treatment bill. If you recall the Overseas Treatment Act, we had a huge debate about this whole issue of domicile and what it means. Now we are also looking at the word resident. Should we provide a definition for the word resident so that once and for all we make a distinction between the two? Or is there already a definition that should apply in these cases? Because domicile here means habitually resident. So what does resident then mean? Because the AG then because you just made the distinction between the two here. You said if a couple from UK comes down here, gets married, can they annul their marriage in the UK? Probably yes, because of some similarities. But in some other countries, it might not be as easy. So
it all depends where they reside, where they are domiciled.
So can we clarify this once and for all? Because we will be using the definition of domicile again, probably in other acts. So maybe we should get it right in the civil code, so that when whatever acts rests on this, we can ensure that it's the correct definition. Thank you.
Just one or two points on the matters raised by the Honourable Afif and Honourable Pillay. Rules. Okay. The current provision says that the jurisdiction is on the basis of domicile or habitual residence. That's the matter that's been brought up in respect of 2291. The definition of domicile that exists is discriminatory. So the committee thought it's discriminatory on the grounds of discrimination against women and discriminating in terms of the birth status of children. So that was eliminated in the committee's thinking for constitutional reasons. That left habitual residence for a period of at least 1 year. That's the existing law. Article 10 in the draft basically describes habitual residence, describes domicile as habitual residence, and the period, the length of the period involved is relevant to determining whether the residence is habitual. So, admittedly, that is complicated, but from our view, apart from the constitutional implication, we saw that that was not a change, although clearly, if you look at the wording, you think, my golly, where is habitual residence gone? But it's now in the definition of domicile, and the old definition of domicile was unconstitutional. So nothing, if you like, has changed. Certainly we had no intention to cover up some major shift. In terms of the definitions, the shift internationally, the various Hague Conventions relating to personal matters have moved from domicile to habitual residence. And that was done because it was no longer a law matter, but it was a matter of fact. Anybody could, so the thought was, work out where did they usually live. Habitual residence is a matter of fact, whereas if the French say it's nationality, whether you're French or not is a matter of law. In the English system, whether you're domiciled or not is a matter of law. Habitual residence is supposed to be fact. So that's what we have. Now, in the progression, the person who lands at the airport is present. That's step one. And that gives rise to very little legal consequence. The next is they're resident. And it may be that they have a house on Eden Island and they're there for a few months each year. That is their residence. But they are not habitually there. The place to which, so to speak, they go home is London or Jersey or Guernsey or wherever most of their money is. So that's, if you like, the progression. And whether it is appropriate to define those things, given that we wish the law to see them as matters of fact to be proved in every case rather than question of technicalities, that is where we're at and the basis upon which the matters have proceeded. And of course, beyond that, there is still a different connection, which is citizenship, and that is, I think, in the Constitution, and that is whether you're a citizen is not a simple matter of fact, it's a matter of complying with legal criteria. The other question, which I perhaps don't have a complete answer to, is partially addressed in the consequence bill on the final page with transitionals. Certainly the shift is to rule-making power by the subordinate legislation power to make that by the president. In terms of the current rules under the Matrimonial Causes Act, what is there at present is that the current law, the current rules will continue in force, and there's a change there both in relation to matrimonial causes and to the extent that the Assembly includes within those property ones on ménage, then there would be a modification of those existing rules to deal with both situations. Chair.
Okay, thank you, Professor. Honorable Wao.
Okay. Thank you, Professor, for the explanation. But I believe that eventually we will need to have we will need to relook at Article 2281. That is the regulation making power. Maybe we will not leave everything to the president, because certain things may be to the Chief Justice or to a minister, depending upon the issue being addressed. Just one thing. I understand. Okay, we've decided to go for domicile instead of residence, but why is it that for an application under Article 256, an application for restraining orders, we have allowed it to be based, or we're basing it on the residence rather than the domicile? No, but it doesn't say property which are in Seychelles, properties which are in Seychelles. It says any property. No, anyway. Anyway, it is not in respect of properties situated in Seychelles. It is any property. Why is it that we base this one on residence? And something else. We're talking, I mean, the proposed amendment in Article 10 refers to habitual residence, but it doesn't refer to what is residence. The Civil Code, presently under Article 102, addresses that issue. What is residence? So we will need to consider that, because either we decide to say we're going to do away with the term residence in the Civil Code and use the term habitual, in that case, for instance, under Article 2292 Roman 2, is habitually is habitually resident in Seychelles. So for consistency, because if we're going to use residence, and the Civil Code has, in respect of its issues of status, it has made reference only to habitual residence, then we should also either, like I've said, for consistency, use habitual residence, or if we're going to use residence, we should also now define what is residence as opposed to habitual residence, which is what is done now presently.
I think the issue about domicile is important because it relates also to where your success, we'll come to this, but it's important with regard where your succession opens. Because when somebody dies, let's say somebody has gone on treatment in Réunion, dies in Réunion, and but he's not domiciled in Réunion. So no, that's right. This is where we need to ensure that. I'm just showing the importance of the.
We need to also define residence.
Right. No. The importance of the issue of domicile. It comes also in Article 718 as to where your succession opens. Okay.
Mr. Chairperson,
yes, Mr.
In our law, just like in French law, we make that distinction between domicile and residence. Le domicile, le lieu principal d'établissement de la personne, you can have only one domicile, which is defined as the habitual residence. And the law also provides that the husband and wife need not have the same domicile. And secondly, la résidence, you can have various residences, plusieurs résidences. Yeah. The only difficulty I have with the point which you raised, I mean, domicile is used for private international law, is under this provision, there is a distinction, first domicile and then domicile or residence, but when you look at it, it's linked with what we call incidental measures. Why you enter divorce proceedings, you can't enter divorce proceedings, but you can enter incidental proceedings if you're resident. That's a question you have to decide. You wouldn't be able to enter divorce proceedings, but matters which are incidental to it, children, custody, or who is to use the matrimonial premises, you permit. You have to keep some coherence about it. You can't enter the divorce proceeding, but you will enter proceedings incidental there to them. Because you're a resident, but not domicile.
Okay, thank you, Mr. Domingue. I think we end now, and tomorrow we'll start with property onwards. Tomorrow we'll start at 9, like our normal sitting, and we'll follow the breaks like we've done today. I'd just like to say thank you to SBC for making the special arrangement today here in this meeting room. We will try, I don't know, afterwards we'll try whether we can actually make it more comfortable. If not, you'll have to stay the same. We cannot improvise better than this. I don't know. No, we don't. This is why we will need to build the annexes and make provision, but that will come in the future. Okay, so we adjourn for today, and we'll reconvene tomorrow at 9, and we will continue the discussion. Bon, pour bon gens qui à l'écoute, nous pouvons adjourner nos débats. Nous pouvons adjourner nos débats au Civil Code qui nous commence ce bon matin. et nous pour continuer demain 9h au matin. Et je remercie les membres publics aussi qui à l'écoute et qui peuvent suivre. Et encore, nous l'appelons, pareil, plusieurs membres fait, leader de l'opposition, leader government business pour matin dans la chamber. C'est bon dimanche, je t'en nous contact, bon qui peut suivre le débat, qui a bon concerne, envoyez-nous. Et merci tous nous tous en propriété. Avec ça, on va dire merci SBC et on va rendre l'antenne SBC et à demain. Merci.